Your Lordship, it is also a fact, and this cannot be disputed, that all the respondents are aware that nomination was a critical area of the presidential election. And that is the effect of the page I've shown you, because the first and second respondent admitted at length that the nomination was so central to the election process that it would affect the outcome of that election. Having known that, Your Lordship, and having admitted that openly, it was improper for them, it was deliberate, and it was...
Sorry, Mr. Uma.
Yes.
You keep harping on submissions by counsel in proceedings before the High Court.
Yes.
What is the evidential value in these proceedings of submissions by counsel in prior proceedings in a different court where a different decision, in fact, was given by that court?
Yes.
What is the evidential value of those submissions for these proceedings?
Your Lordship, this petition, when the petitioner became aware of the illegal activities, they moved the High Court on the same petition. And the matters were similar, the matters were the same, and in fact, the same petition is annexed to these pleadings. It is the third respondent who are telling us nomination is critical, but this is the wrong forum. Now we've brought them to the right forum, where they wanted us to come. And therefore, that is why Mr. Musyoki was saying that we still hope their position is the same. Because this is something that is given in public, forms part of the public record, and is an admission. Your Lordship, if you were to look at the decision, it was so controlling to the judge's decision that the judge had to down his stool and say that nomination must only be had by the Supreme Court. Yes, that is the importance of that authority.
My Lord, my understanding of the law is counsel cannot make an admission on law. It can only make an admission on facts. So even if my learned friend did make an admission on the law, that is not binding on the court, and the court is still entitled to ascertain what the law is in the particular circumstances.
That's exactly just Serena's question.
Yes.
I mean, counsel could be making an erroneous admission for that matter.
Absolutely.
Yes, it might be an erroneous admission, but when counsel is appearing to court, he's representing the position of his client. When I'm speaking here, I'm an agent of the petitioner. I'm not speaking on my own. And when I'm acknowledging that this is a critical process that can determine the election itself, then I'm representing the position of the petitioner. The petitioner cannot say to not know what I'm saying in court, because he is affected by any decision that I say in court.
Mr. Oma, if you remain faithful to your petition,
Yes.
just keep watching the clock.
Yes.
Time will run out before you finish your
Yes, I have noted that. Your Lordship, I would wish to reiterate the importance of nomination by citing authorities that have been decided both in Kenya and elsewhere. And the first authority was the case of Karanja Kabage versus Joseph Kiuna that you cited in your decision of the 1st of September. And you stated, and that court stated, that there are certain conditional precedents. There are certain constitutional necessities that are precedent to the conduct of an election. And it gave an example of nomination as one of those conditional precedents.